Morning, everyone. Thanks for joining us. We're going to have a couple of minutes just to let everyone else join this morning. We'll get going in about a minute or two. I see more of you joining, so yeah, we'll give it a minute. Gives you a chance to check your local election results. Cool. Okay, so at 9:01, we've got quite a bit to get through on today's webinar, so I shall kick off. So a very good morning to you all, and thank you for joining us for our 6th K3 Hub CPD webinar of 2024. My name is Adrian Howells. I'm a Managing Director in the Deals and M&A Specialist at Quantuma, which is part of the K3 Capital Group. As today's webinar is discussing HR and people management aspects of mergers and acquisitions, I want to set the scene for you briefly and touch upon what we're seeing in the current M&A market before I hand over to our speaker, Tony Trevitt. And frankly, the timing couldn't be better, what with a truly seismic shift in the political landscape we have seen overnight. With the election results hot off the press, your business owner clients may be wondering about the state of the market and whether this is a good time to sell their business. In my view, business owners would be advised to act now for the best outcomes, and I shall explain why. If we look back over the last year, we've seen a combination of high interest rates and constrained economic growth. This has meant that deal appetite amongst trade buyers, private equity investors, and other acquirers has been somewhat subdued. However, with the right support, sales have still been getting done. In fact, our corporate finance team led deals to help over 20 founding owners sell their businesses last year, and this year is shaping up to be even more active. There is still activity across all sectors. The companies we have helped support over the last 12 months have ranged from LifeCast Body Simulation, a globally renowned leader in the design of medical mannequins, to Challenge Packaging, a Sussex-based packaging manufacturer. Economic uncertainty does mean that deals are taking longer and buyers are being more selective. We are finding that buyers are asking more questions and carrying out more extensive due diligence. This means that transactions that would previously have completed in 6 months can now take nearer to a year. Now, the good news here is that a transaction starting now will benefit from an end to months of political uncertainty and also reach out into a more certain economic future. Looking forward, when talking to your clients about the sensitive subject of succession planning, you may naturally want to err on the side of caution or even shy away from the topic altogether. However, building equity value in a business and realising it through an exit is a natural part of the business life cycle, which shareholders will be keen to discuss and plan for. Waiting for an economic recovery to take hold could actually diminish the chances of success and open up more risks for business owners than going to market now. In our view, it is never too early to have a conversation about exit plans, and having a conversation earlier does have several advantages for business owners and you, including allowing enough time to get the deal done, taking advantage of favourable prices, which we are still seeing, avoiding potential rises in capital gains tax, and let's think, when is that first budget going to be and what will it include? But for you guys, equity transactions can create fee opportunities as well, whether you are an accountant getting the numbers and the forecasts deal ready, or a lawyer ensuring that all contracts are robust enough for detailed scrutiny. At Quantuma, we also offer a generous referral scheme for introducers. So circling back to my original question, is this a good time for your clients to sell their business? In my view, your clients would be advised to get the wheels in motion now for selling their business. So the answer is a resounding yes. On to today's session, and I'm delighted to welcome back Tony Trevitt, one of our regular speakers. Tony is a qualified HR practitioner, mediator, trainer, and coach. She's worked for both large and small companies in HR and employee relations roles, so she understands the impact of merger and acquisition can have on staff. Amongst other things, she'll be talking to you through some of the key reasons why mergers and acquisitions fail, TUPE and the redundancy process, and how to avoid losing key staff. Just before I go, a few bits of housekeeping. Today's session is being recorded and should be available on the K3 Hub and Quantum websites next week. The Q&A function is open, so do feel free to ask questions as we go. We're going to run some short polls during the webinar just for fun, so feel free to participate. Your responses are anonymous. And you'll see that we've posted today's presentation in the chat box, and we'll do so again for any latecomers. Thank you again for your time today, and I hope you enjoy the session. If you want to reach out to me, I'd be very happy to have a chat with you. My details will shortly be posted in the chat box if they haven't already been. I wish you a great weekend, and Tony, over to you.
Lovely. Thank you very much, Adrian, and thank you everybody for joining us again today. So as Adrian said, we've got a few hours this morning, and I am really pleased to be asked to come back and talk to you again. And this time, as Adrian said, we're really focusing in on those HR and people management aspects of mergers and acquisitions. And people are often an organisation's most important asset, yet some of the major reasons why mergers and acquisitions fail to achieve what was expected is because of employee-related outcomes. And I've worked with many organisations over the years undergoing mergers and acquisitions, both as an employee and also in a consultancy role. And I would definitely say I've learned the hard way what not to do and what you should definitely do. And everyone is also different. So even though we'll talk about key themes and areas, you know, you do have to look individually at each scenario, each situation. Years ago, I worked at British Airports Authority, BAA PLC, and one of the areas of our business was cargo and ground handling. And we had some groups of employees that had 4 TUPE transfers, that's the Transfer of Undertakings Protection of Employment regulations, in as many years. And to say that that group of employees were suffering from severe change fatigue would be a bit of an understatement. That's a lot of change for anyone. I've worked with haulage and logistics companies, endless service provision changes, as you might expect in the transport arena, where contracts change hands and sometimes fairly regularly. And more recently, I've worked with a healthcare employer with endless people and culture problems resulting from an acquisition, where really the leadership just didn't deal with issues and were nowhere near proactive enough. So I've seen lots of different scenarios, and hopefully will give you a few thoughts or reminders and ideas today. Please sing out with any questions. We'll have a couple of breaks. I'll aim for around the hour point. And if there are questions, put them into the box, and I'll try and answer them when we get back from the break. So that's a very brief introduction. Adrian thankfully gave an introduction to me, so I don't need to do that again. But I've got more than 20 years of working as a consultant, and in pretty much every sector. So even though there are similarities, there are also a great deal of differences. When I first started out, I knew a lot of employers, when they go through, particularly time-consuming issues like mergers and acquisitions, they just don't have the bandwidth with current employees to deal with these things. And often that's where the problems start, right from the beginning, where people with busy day jobs are expected to pack in a lot more where there's a merger and acquisition in the offing. So if you are ever involved, do think about realistically whether you need more support in order to get these things done well. And I'm really fortunate to have a really diverse life as in my professional life. And I also sit and hear cases, as you can see there, for the Employment Tribunal service, which is the part of the judiciary that deals with unfair dismissal and discrimination and breach of contract and all those kind of things. So that's me. Let's just have a reminder in a bit more detail of what we'll do today, what we'll look at. So our agenda is up there on the screen. We'll start with a bit of an employment law deep delve into TUPE. And I remember the HR chat leading up to Brexit, which was, will TUPE be repealed? Will we finally escape this legislation? But of course, we didn't. And we do have a few changes pending on the current regulations, so we'll touch on those as well. So we'll spend a bit of time on TUPE. We'll then move on to the essential people management piece, leadership styles, and there are a few ways that we can promote a more positive merger and acquisition by how we interact with people. We'll talk about communication, absolutely a linchpin for the HR and people piece. And then we'll end by looking at culture, integration, fit, and we'll finish on retention and how to avoid the loss of your important or key talent. So as I said, we'll have a couple of breaks. I'll certainly keep an eye out for questions. But that's basically what we'll do with our time together. So just a really brief reminder of what is the difference between the merger, acquisition and a joint venture. Well, both the merger and acquisition entail two companies becoming one normally. There are differences though. A merger is when those companies combine to form a new company. So it's much more of an equal process for the most part. An acquisition is where one company buys another, and often the company that was bought will then cease to exist. And a joint venture involves more of a strategic partnership where separate entities unite to achieve specific objectives, but they retain their autonomy. And although we're not talking about it today at all, let's not forget separations, and where organisations leave each other, or parts of an organisation does, because there's a similar people focus in those areas as well. Okay, so we're going to start with a question. So anyone that's been involved in a merger and acquisition before, hopefully there are a few of you here that have, or have been an acquired, merged or TUPE'd employee, I'm really interested to hear how you would rate the success of that. So we've got 4 options for you: 100% smooth and successful, relatively easy and successful. Obviously, successful is quite, there's a broad scope as to what successful might mean, but think about it in your experience. A C is difficult, but eventually successful. And D is disastrous and entirely unsuccessful. So please ask away. You've got 4 options. We'll give it a minute or a little while so you can answer that question. Okay, let's see what the answer is. Here we go. Hopefully you can see this. So we've got 16% that say 100% smooth and successful. We've got 47%, but there's our majority, relatively easy and successful. 37% difficult, but eventually successful, and no one in the disastrous and unsuccessful category. So that's good news. That doesn't surprise me. I think the the split between it's difficult, but it was eventually successful, and the majority, the small majority there with relatively easy and successful. Now, the statistics are interesting because according to the Harvard Business Review, back in November 2023, between 70 and 90% don't quite make it across that elusive finish line in the successful way that was intended or hoped for. So this is stats over the last 45 years. And although there's lots of really successful stories and mergers and acquisitions, many don't result in the increased operating profits that, maybe the economics textbooks would have led them to expect. And the consultancy firm McKinsey report on this as well. And they recently had a big paper on it, which said anyone who's researched merger success rates know that roughly 70% do not achieve what was intended. Now, that's a really high statistic. And although there's lots of non-people reasons for that, including poor or insufficient due diligence, overpaying, operational difficulties, synergy overestimation, high recovery costs, market challenges, lots of non-people related reasons. There's also lots of people related issues. And of course, that's what we'll focus on today. Thank you for doing that. That's really helpful to see, to have your experience. So what we're going to think about is ensuring compliance with HR-related law and regulation first. So those include things related to benefits, compensation, employee relations, and are all captured by the TUPE legislation, which I'll come on to. We'll touch on the due diligence process, and that's part of our TUPE obligation as well. Conducting thorough due diligence on the human resources aspects of potential acquisition targets means a careful review of remuneration, benefits, compensation, performance management practices, all those things that are costly and also make up a large part of our employee relations piece. We'll talk about developing workforce plans. That is really important. It needs to address the impact of that transaction. And obviously that can include identifying potential redundancies and reorganisations. You should definitely be highlighting key employees and preparing talent development plans as part of that process. We'll look at proactive talent retention strategies as well. Keeping key employees is absolutely imperative. As I've said already, identifying those high potential people and critical talent and having customised retention plans is really important. Many companies end up offering retention bonuses or mapped career development opportunities, progression pathways, lots of ways to reassure employees that they have a great future with the merged entity. Communication, I always say to people, plan what you want to communicate and then double it, because nobody complains that they had too much information, that they were well informed, that they had lots of regular opportunity to ask questions. It's always the other way around. So communicating with employees about the transaction, its impact, what will be different, what will be the same, answering questions, encouraging people to raise concerns is essential. The whole of this is really about change management, managing people through change. So we need to address what those resistors are, where people resist change, communicate the benefits of the transaction, have that culture of integration as an ongoing theme. And then post-merger, there often needs to be a bit of a focus on the HR integration. What are the right systems? What are we doing with policies, procedures and practices? How do we make this as smooth and easy a transitioning process as possible? And that will all, centre into aligning and identifying any culture clashes or misfits in that area too. So most of those things we'll touch on today, but hopefully that gives you a bit of a generalised summary about the different areas you would need to think of when looking at the HR and people management piece. So let's move into TUPE first. So the first part of our agenda is just to talk about the fact that TUPE has as its purpose to protect employees in the event of a relevant TUPE transfer. And its effect is essentially to move employees and most of their liabilities associated with that from the old employer, known as the transferor, to the new employer, known as the transferee, and this is by operation of law. And it preserves an employee's rights after transfer, and if needed, allows the new employer to also explain any changes they're planning. These are known as measures in the legislation, and why the transfer is happening as well. And these regulations are long-standing. They were first passed in 1981, overhauled in 2006, further amendments made in 2014, and we've got some tweaks coming this year too. And it's a significant and often quite tricky piece of legislation adopted by the UK in order to implement the EU Acquired Rights Directive. If you're involved in TUPE transfers at all and not familiar with its obligations, it's quite prescriptive, definitely increase your knowledge and get some good advice, because it can be quite expensive to get this bit wrong. So let me tell you a little bit more about it. The knowledge you definitely need to understand when it comes to TUPE is, firstly, when TUPE is likely to apply, because not every transaction will fall within the TUPE boundary. Secondly, I would say, is what the TUPE legislation means for employees, because you will be getting lots of questions about that. Thirdly, what you have to do to comply with TUPE as an employer. And it's different whether you're the incoming or outgoing employer, and there are penalties for failing to comply. Then you need to understand the implications if TUPE doesn't apply, because it does change the process and what you need to do. And then finally, what steps are there for you to protect your business from the effects of TUPE as well? And we'll touch on those over the next 3/4 of an hour, probably. If you're looking for information online, there's lots of it. ACAS and .gov.uk have really good summaries. So I would probably say that's the first place to start. And it's broken down on both of those sites into nice, easily digestible chunks, as I've just set out for you. So I would start there if you're looking for more information. So TUPE can apply when employers either sell or buy part or all of a business as a going concern, essentially as an economic entity which retains its identity. So that's the first time that TUPE can apply. Secondly, it applies where there is outsourcing. So where you make a service provision change which involves either an initial outsourcing of a service, i.e. where a service transfers from one customer to an external contractor. B, a subsequent transfer, i.e. where services transfer from the first external contractor to a different external contractor. So that's often via a kind of a process where the contractor would lose its contract and it passes to another. And then C, where you bring the service back in-house. So where the service transfers from external contractor back to the customer. And then we've got the last option there, grant or take over a lease or license of premises and operate the same business from those premises. So these are all what's called relevant transfers. And TUPE applies where there is a relevant transfer and the identity of the employer actually changes. It doesn't apply when the shares in one company are sold to another, because in that scenario, the same company continues to be the employer. It would also not usually apply where just the physical assets of a business are transferred, unless employees are not taken on by the new employer to prevent TUPE from applying. So this is where an employer will terminate the employment of employees to make themselves more attractive. And that, of course, would not be lawful. And the 2006 regulations clarified this complicated this complicated legislation and some case law to determine what a relevant transfer means. And that's why I've kind of stressed a couple of times this economic entity which retains its identity point. So you look at the type of undertaking being transferred, what tangible assets are being transferred, buildings or movable property, whether any intangible assets are transferred and the extent of their value is often looked at too. And then into the employees. So are the majority of the employees in that business or part of the business being moved, taken on by the new employer? Are any customers being transferred? What's the degree of similarity between the activities carried on pre and post transfer? And then finally, the period for which the activities were suspended, if any, prior to the transfer. So I know that's quite a lot of detail there, but whether something is a relevant transfer or not is kind of rule number one. We've got to get that assessment correct. And it can be quite complex. So again, if need be, take some specialist legal advice. Cool. Okay, let's move on. So we've got another question for you. So the question is, TUPE is not relevant to an intra-group transfer. So that's a statement. The question for you is that true or false? So TUPE is not relevant to an intra-group transfer, true or false? And again, I'll give you a few seconds to pick between the two, true or false. See what you think with that question. Have we got an answer? Here we go. So thank you for doing that. As I can see there, 23% of you think it's true. So TUPE is not relevant to an intra-group transfer, but 77% think it's false, i.e. it can be relevant. And the majority here have it. So 3/4 of you are absolutely right. The answer is false. TUPE can be relevant to an intra-group transfer. So the transfer of a business within a group can qualify as a relevant transfer in the same way as a transfer between two unconnected parties can be. And in many group reorganisations, the only change will be to the identity of the employer. However, even in those cases, there is still a requirement to inform and consult if applicable, and I'll come on to what the information and consultation obligations are in a minute. They have to inform and, if applicable, consult appropriate representatives of the employees involved in that transfer. And this is really easy to overlook, and there are formalities, even in a seemingly straightforward transfer, that have to be complied with. It is really important to comply, as a failure to inform and consult can result in claims of up to 13 weeks' pay per employee, and that's uncapped, that's actual pay. So even if the only change is the identity of the employer, this is still a TUPE transfer. Of course, if that also means there are changes to terms and conditions, the place of work, any of the other issues connected with that transfer, then TUPE, the TUPE principles obviously continue to apply, and employees may not be bound by any detrimental change. And I'll explain more about that in a minute too. So thank you for doing that. So what does TUPE mean legally for people? Well, as I mentioned, employees employed in the undertaking, which is being transferred, have their employment transferred from their current employer to the new employer. And TUPE states that all the transferor's rights, powers, duties and liabilities under or in connection with the transferring employee's contracts are transferred to the transferee. So everything does. It's an all-embracing concept, encompassing rights under the contract of employment, statutory rights, continuous service, so your service doesn't restart. It is as if you had always been employed by that new employer. And that means that employees' rights to bring a claim against the new employer for unfair dismissal, for unfair redundancy, for discrimination, for unpaid wages or bonuses, all of those things transfer too. So it's really important that we understand what that means and make sure we apply that to the transferring employees. Employers also have the legal right to transfer, as I said, with all their existing terms and conditions, rights and liabilities, including those connected to old age pensions and occupational pension schemes to some extent. And we'll talk about that in a minute. So effectively, the new employer steps into the shoes of the old employer, and there should be no difference. And for this reason, it's essential that employers know what they're going to inherit. And if they're planning to take over a contract or buy a business, that they make sure that the contracts protect them from any employment liabilities which arose before they became the employer. This is all part of due diligence and the information sharing prior to the transfer. And it's definitely helped by the fact that the outgoing employer is required to provide in writing to the new employer written details of the employee's rights and liabilities. And obtaining this information is a legal requirement, and I'll talk you through what that is in a second. So imagine, ABC PLC has been carrying out a contract. Let's say it's for an insurance company, and they supply IT services. If they lose the contract and that is awarded to 123 Limited, then 123 will not only take over the contract to supply those IT services, but they also inherit all of the employees employed in that undertaking. So the employees of ABC transfer to 123. If ABC had failed to pay its employees their last bonus, for example, or were financially in trouble and hadn't paid the last wages, then the new employer, 123 Limited here, inherits that liability for the unpaid wages, unpaid bonuses under TUPE. And this is why this whole due diligence is essential pre-transfer. And I've seen this so often. And then thirdly, any dismissals that arise from the transfer will be automatically unfair if the dismissal reason is the sole or principal reason, and that is connected to the transfer. So dismissals may not be automatically unfair if there is what's called an ETO reason, an economic, technical, or organisational reason that required a change in the workforce. And this is critical if you want to make redundancies post-transfer, for example. This ETO defence is pretty narrow in scope, though, because it has to entail changes in the workforce, i.e. the number of people or the job functions. So it's not enough to say we want to make change. That change has to entail changes to the workforce in terms of numbers or job functions. So ETO reasons can sometimes be difficult to establish. Of course, if there is a genuine and clear need for redundancy and we're downsizing, then that's definitely going to tick the ETO box. Even if the employer can rely on an ETO defence and the dismissal is therefore not automatically unfair, it could still be unfair if you don't follow the right process. So we have to have proper consultation in redundancy situations and comply with everything you would normally do in a redundancy. So there's extra complexity there, if you like. Okay, I've got another question for you, keeping you busy, first thing. So if I object to the transfer, do I stay with my employer? Yes or no? So if somebody doesn't want to transfer, and this happens quite regularly too, so they object because the law allows you to object, do they get to stay with their employer? So if I object, do I stay with my employer? Yes or no? Have a quick choice on that question too, please. So we give you a couple of seconds to pick between the two. And the answer's coming up. So yes, say if you object, you get to stay with your employer. So 22%, just under a quarter. And the rest say no. If you object, you don't get to stay with your employer. And again, the majority here is right. Objecting to a transfer means that the employment ends on the date of the transfer. So they don't work their notice, they haven't resigned, they're free to go and work elsewhere immediately, but they don't get to stay. They don't need to give a reason for objecting either. The law doesn't require that. It simply says an employee can object. Also, people are normally released from restricted covenants and post-termination restrictions in their contract. There was a High Court case not so long ago where the new employer was unable to enforce restrictive covenants against an employee because their employment never transferred over to it. So it's quite an important point, this. And then it's also, as I said, not viewed as a dismissal nor as a resignation. In fact, the employee is not entitled to any compensation. So if someone objects, their employment will end on the date of the transfer and they don't need to work their notice. However, there are a couple of exceptions. Aren't there always? Is the legislation ever that straightforward? Of course not. So two important exceptions where an objection is deemed to be a dismissal. So if the employee objects on the basis that he or she has been constructively dismissed, so the changes are such, or the proposed changes are such, that they feel they have to object because it would amount to constructive dismissal, then that's the first exception to what I've just told you. And the second exception is where the employee objects in response to material detriment, and they too can treat themselves as being constructively dismissed. So it's not as simple as they've objected, I have nothing to worry about, because although someone doesn't have to give a reason, the reality of the reason could be, substantial change, material detriment, or, other action that leaves that person believing they've been constructively dismissed. So again, the whole managing information and consultation to ensure we don't leave ourselves in this position is really important. Okay, thank you for that. Let's talk terms and conditions. Under it's Regulation 4 of TUPE, not that it matters, but it says that all the transferors' rights, powers, duties and liabilities under or in connection with any such contract transfer from transferor old company to transferee new company. And this means that contractual employment entitlements, and think, commonly salary, benefits, holiday, working hours, notice periods, all those things will transfer, and the new employee is obliged to honour them. It's sometimes thought that discretionary entitlements don't transfer, and that's not quite right. They too can pass over to the new employer as liabilities and powers in connection with the employment contract. Because remember, the definition I read to you was that all the transferors' rights, powers, duties and liabilities under or in connection with the contract. So that's why often discretionary entitlements transfer too. So for example, if an employee's contract had an entitlement to a discretionary bonus, very common, an employer is obliged to act in good faith when considering whether to award a discretionary bonus or not. That's an implied obligation. So where a TUPE transfer occurs, the new employer cannot simply disregard the discretionary entitlement and simply say, we exercise the discretion not to pay anything. Instead, the new employer would be required to act in good faith in any decision not to award a bonus, in the same way that the old employer would have been required to act in good faith. So TUPE preserves rights. It doesn't create rights where none existed in the first place. So take the scenario where someone transfers to a new employer and they've got better benefits or other benefits. They don't get to have those benefits because they've now transferred. So it doesn't create rights where they didn't have it in the first place. That also means that a purely non-contractual policy would not be enforceable against the new employer if it was not enforceable against the previous employer. Okay, so staff handbooks and other non-contractual policies would arguably only transfer to the extent that they have been incorporated into the employee's contracts, either expressly or by implication, before the transfer. Okay, so it doesn't change the status of some of those things. But implied contractual rights are really important, and you've got to have those as part of your due diligence. My example of a bonus scheme described as discretionary, but which has been paid year on year in a similar manner, well, there's an argument that that's going to be an implied contractual right. Whether the calculation metrics, the target amount, whether those things change to some extent or not, they may still give rise to an implied contractual right to receive a bonus of some amount. So due diligence is key. I'm sure you'd realise that in any event. Incoming employers, the transferee has to get as full a picture as possible of all of those things. And don't forget pension rights too. transferring employees have often have pension rights. Most occupational pension scheme rights are, however, completely excluded from TUPE, so pension rights don't automatically transfer with transferring employees, but employers do have to arrange certain minimum pension provision under the pension legislation, and this is separate from TUPE. So where transferring employees are part of an occupational pension scheme, or don't forget, are entitled to join one, the incoming employer does not have to contribute to occupational schemes, but it must provide a reasonable alternative and match an employee's contributions to a stakeholder scheme up to a minimum of 6%. So the pension piece, I'm not going to go into in any more detail, but it will be relevant for you to look at. The exclusion from the automatic transferring employees of all rights that normally happens under TUPE only applies to benefits under occupational pension schemes. So you've got to check the type of pension scheme as well. And if the pension rights are not old age, so invalidity or survivors schemes, some pension obligations do transfer to the new employer. And in public sector service provision situations, there is specific government guidance and rules on those as well. So I won't go into more detail. Hopefully you get a flavour for the complexity with pensions and in fact all the other areas of TUPE. And if you need support, please make sure you get it. Okay, so who gets to transfer is the next thing we need to talk about. Well, case law has developed something that's called an assignment test. And there are several factors used to identify which employees should transfer. And what it's known normally as is are these people wholly or mainly assigned? So we need to look for this degree of assignment. And remember, something which is temporary is unlikely to ever be an assignment. So long-term secondments could still include an assignment, but something that's very temporary may not. So we have to look at the degree of assignment. This also includes fixed-term staff, but it excludes agency staff. And sometimes you end up having to assess what time people spend on transferring undertakings or activities and look at the kind of duties they carry out. So imagine where part of a business is subject to a TUPE transfer, and some people work partly on that part that's transferring and partly on parts of the business that are not transferring. Well, then we need to look at, are they wholly or mainly assigned? And what gets bandied around often is the 50% plus test. So does an employee spend 50% or more of their working time on the transferring business or part of the business? And if so, they will typically transfer with that part of the organisation or that organisation. So we need to look at who gets to transfer. I think often it's fairly obvious whether an employee is wholly or mainly assigned to a transferring undertaking or service. However, uncertainty followed from a European case that was heard in 2020, which was ISS Facility Services, NV, and they ruled that a full-time employment contract can be split between multiple new employers where a TUPE transfer involves two or more organisations. So in this case, some people had their employment contract passed to two new employers. So you now work 40% of your time with employer A and 60% of your time with employer B because you've transferred from employer C. And prior to this case, it was widely understood that an employment contract could not be split as part of a TUPE transfer. So this case was a bit of a big deal. We then had a UK decision in 2021, which, however, confirmed that it may be possible to transfer only part of an employee's employment to a transferee where their working time is split. So, you know, a complex area. Another important consideration when identifying who will transfer is that TUPE only applies to employees, but the test of who is an employee is slightly different to what we're used to. And in 2019, a UK employment tribunal decided that those who had the worker status were also protected, as were employees under TUPE. So it was no longer just the employees, it was also the workers, because hopefully you'll be familiar that we've got three types of people that work in organisations. We've got classic employees, we've got self-employed, and then we've got the middle group classified as workers. So this case was Dewhurst, and it concluded that TUPE applies to workers as well as employees. Anyway, so some complexity as to who are the people that will transfer. Now, I mentioned to you right at the beginning that we've got some changes. So in saying what I've just said, we do have a few issues in terms of new legislation on these points that may change things. So the government has now tried and is planning to clarify who TUPE applies to ensure that it's only employees that can be transferred to a new employer. And only employees can be transferred to one new employer in situations where there are multiple parties involved post-acquisition. So what I've just said, being the situation currently, the government's planning to legislate to change that. And the Department for Business and Trade has published consultation that seeks views on these planned changes to TUPE, i.e. that it will only apply to employees and not workers. And the consultation also proposes to amend the regulations to clarify that employment contracts can only be transferred to one employer and cannot be split between multiple organisations. And it's really impractical to do that in any event, because how could you imagine it's split to very diverse parts of the country, for example, and it's on-site working. It's just practically really difficult. So dividing employees' terms and conditions between multiple parties is obviously really challenging. So we've got those changes pending, so watch out for that. It might simplify those extra complexities. Okay, next I want to talk about the role for trade union reps in TUPE transfers, or where there is no trade union recognised, the need to elect employee representatives. So this is into the information and consultation piece. If there are recognised trade unions or authorised employee representatives, you must consult with them. If, however, there are no employee reps and an employer has fewer than 10 employees, then you don't have to elect representatives. You inform and consult directly with employees. So those micro, small businesses don't have the burden of having to elect representatives. And this is being further extended in our legislation now. So in fact, it changed on the 1st of July. So for transfers completing on or after the 1st of July, employers can inform and consult directly with employees if they have fewer than 50 employees in total, or they are transferring fewer than 10 employees. Okay, so in smaller businesses, we may find this exception helpful. If you have no trade union and the exemptions I just told you about don't apply, then you need to arrange elections for employee representatives. And when you do that, TUPE sets out some rules for you. So if you're not one of those small organisations and you don't have a trade union recognised, you have to elect representatives. And we need to make sure the election process is fair. We need to decide, so the employer decides how many people are needed to represent the interests of everyone affected. We need to decide if affected employees should be represented as one group or several groups. And then we need to decide how long we need to have representatives in place. And all employees are able to stand for election if they are affected by the transfer at the time of the election. And no affected employee should be unreasonably excluded from standing for election. So all affected employees at the time of the election are entitled to stand. And then when we know who is standing to be an employee rep, then all affected employees are entitled to vote. and employees can vote for as many candidates as there are positions to fill. And if possible, that should be voting done in secret. And we also need to make sure votes are accurately counted. So there's whole election piece. Again, it's set out in the legislation that we need to follow where we need to elect representatives. And I think it's good practice to encourage employees to stand for election. And I've even given, where nobody has wanted to, given them a second chance to do so, and actually then communicated what it means, you know, because I think people worry that they have a great burden. However, if the election fails to attract candidates, then you go back to consulting with each employee individually. But I think it's good to encourage nominations. Where the transfer is quite big, it's so much easier to have representatives. So reassuring staff that they'll get training, for example, setting out a Q&A, what the role of a rep is, explaining what their rights are, might also help people want to stand. In bigger transfers, trust me, it's much easier to have reps than to have to inform and communicate with all employees. And the final point to mention on reps is that during the consultation, the law sets out the rights of employee reps. So they have the right to a reasonable amount of paid time off for their representation duties. They have the right to reasonable access to affected employees as well as workplace facilities, and they get paid time off for this role as well as any training that you provide. And then finally, you cannot dismiss an employee or treat them unfairly or subject them to a detriment because they are either a trade union or an employee rep. So lots of rules on who we're going to consult with. And I've tried to take these things in order in TUPE. So next on our list, we know who's transferring. We know it's a relevant transfer. We've got the situation sorted with representation. The next thing is under TUPE, there's a requirement to inform affected employees, which includes those that transfer from the old employer to the new employer. It also includes informing those that are staying employed with the old employer, but whose colleagues will transfer out, and there is some change that will affect them. And it also includes employees already working for the new employer whose work will be affected by staff transferring in. So it's not just about the group that are going from one employer to the other. We also need to think about those impacted at the outgoing employer and those impacted or affected with at the incoming employer. Okay. So then we've got information obligations in a couple of ways. The first thing is that we've got to give information to the representatives. So this is prescriptive. This is what you have to do. We have to tell them the fact that the transfer is to take place, the date or proposed date of the transfer, the reasons why it is to take place, the legal, economic and social implications of the transfer for affected employees. Remember, affected employees are in those three groups. And then any measures proposed in connection with the transfer that will affect the employees. And if there are no measures to be taken, then we simply say that there are no measures to be taken. So that needs to be covered off in information to the representatives. In addition to that, there is something called employee liability information. So further information must be supplied also in writing to the new employer. So not to the reps, but to the new employer, to the transferee. And that basically details the rights and obligations for the employees that will transfer. And that information has to be supplied at least 28 days before the date of the transfer, although often it's asked for and helpful to provide it at an even earlier stage. So this is called the employee liability information and goes to the new employer, not the reps. And I've put on the slide there everything that must be included in that ELI piece of communication. So identities of transferring employees and their ages, all the information contained in the transferring employees' written contracts of employment, or also known as statements of particulars, Information about any collective agreements, that's collective agreements with a recognised trade union, if there is any. Details of any formal disciplinary action taken in the last 2 years for any transferring employees. Same for grievances, and details of any legal action brought against the old employer by any of the transferring employees, again, over the last 2 years, as well as potential legal action, so what might be brought. And also the total number of temps and agency workers working temporarily must also be provided too. Again, this is all prescriptive, it's all within the legislation, and you kind of follow it, you know, step by step, to be quite honest, to make sure you don't miss anything. Then once all the information piece is done, we move to the consultation stage. So in addition to informing, consultation must also take place with the reps, or if one of the exemption applies that I told you about earlier, directly with employees. And this consultation is about any proposed measures. And we have to consult, what the legislation says is, long enough before the transfer to enable the outgoing employer to consult with them about it. So the information goes from the old employer to the new employer about the employee liability information. Then we have to advise the old employer if there are any measures that might take place, so the current employer, the old employer, can start the consultation process. So let me just recap that for you, because it's quite confusing. So in addition to the information I've mentioned, consultation has to take place with the reps unless there's one of those exemptions. And that is about proposed measures. So it's only the new employer that is likely to take proposed measures with the transferring group. So the new employer must tell the current employer what might change, what those measures might be, long enough before the transfer to enable the current employer to consult with reps about it. Okay, so all affected staff must be included when consulting about the transfer. So that might include people on sick leave, on maternity or adoption or parental or paternity leave. So we've got to make sure we think about those that aren't necessarily visible as well. And the duty to consult kicks in when there are any measures or consequences that the new employer envisages that the transfer may have on the affected transferring group. Remember too, there could be an impact with the existing staff that aren't moving and the new staff and the existing staff with the new employer. So we've got those 3 groups to think about. So are there any measures or consequences that affect any of those people by reason of the transfer? And even where there are no measures being proposed, our case law suggests that employers should still look to consult in any event on a voluntary basis, just to help from an employee relations point of view. It will definitely help the process run more smoothly and avoid issues where the communication takes place. So what is a measure? Well, measures are essentially things that will happen because of the transfer, and it could be positive or negative for employees. For example, there could be a change in the place of work. There could be a change to some benefits. We talked about pensions earlier, which are very likely to be impacted. There could be a change to the date employees are paid, for example. There could be changes to working practices or shift patterns. There could be redundancies. So measures are pretty broad as to what could be different as a result of the TUPE transfer. So both the transferor, old company, and the transferee, new company, have this information and consultation obligation if there are employees affected by measures in respect of the transfer. Both transferring employees, those that go across, and non-transferring employees could have change that needs to be part of the consultation. And the law says it must be meaningful and with a view to reaching agreement, but agreement doesn't actually have to be reached. It's not a negotiation, it's a consultation. So TUPE requires only that the employers involved must consider representations raised by the reps and explain if they are rejecting those representations, why they do so, and give reasons. So it's about listening, sharing, responding, consulting. So I'm often asked, well, how long does consultation have to last? Well, unhelpfully, TUPE doesn't have a period of time. There's nothing specified as to how long employers must consult with the representatives as part of this stage of the TUPE process. All it says is that the required information must be given in good time and long enough before the relevant transfer to enable the employer of the affected employees to consult affected employee representatives. So we're back to the, give the information in good time to enable meaningful and genuine consultation to take place. So consultation will continue until either agreement on matters and measures envisaged has been reached, or until it's clear that there is no prospect of agreement or further agreement between the parties. So you consult until you reach agreement on the measures envisaged, or it's clear that we're not going to be reaching agreement. And this obviously is going to depend on the facts and circumstances in each case. How many measures are proposed, how controversial they are, how much conflict there is. If you've got a couple of extremely minor changes, it seems unlikely that a process of consultation will take more than, a couple of meetings, assuming you've got reps already in place and you don't have to do the whole election piece as well. The larger the transaction, the more people affected, the more measures there are, the longer the consultation is likely to take. So the answer to the question, how long must consultation take, is there is no period of time, but we have to make sure we tick the genuine and meaningful consultation box. Okay, I just wanted to also tell you that if you fail, I think I might have mentioned this already, but let me just reiterate it. If you fail to inform or consult, then you may be jointly, new and old employer jointly, or individually liable and taken to an employment tribunal by either the affected employees themselves and or any recognised trade union representatives. And if successful, if they can show that there has been a failure to inform or consult, or inform or consult adequately, genuinely, then the tribunal can award whatever compensation it considers just and equitable, having regard to the seriousness of the failures, up to the maximum of 13 weeks gross actual pay per affected employee. So it's quite expensive, up to 13 weeks gross pay. It's quite a lot in compensation. If the employees or trade unions claim that the tribunal is successful, then the employer has to pay the penalty, even if it was the outgoing employer's failure to consult properly, because remember, liabilities pass over to the new employer. But sometimes, it results in joint and several liability between the outgoing and incoming employers. You may have contractual warranties and indemnities, which we'll come on to, that will indicate who actually pays at the end of the day. But there is the whole compensation piece. So the failure to comply with TUPE could expose an employer to quite large compensatory payments, which could undermine the entire transaction, to be quite honest. So you will have failed to inform and consult if there was a recognised union and you didn't consult with their reps, where there was no recognised union and you didn't elect properly employee representatives, where you didn't genuinely or meaningfully consult with representatives, and if you have fewer than 10 employees and you didn't consult with the employees directly, then that would be a failure too. So lots of reasons that there could be a failure. So again, understand the process, have a plan, get advice if you need it. So I'm going to do 2 more slides and then we'll stop for a break because that seems logical to me. So the next point is, what practical steps can you take to protect your business from the effects of TUPE? Well, you can't contract out of TUPE. You can't say, well, we'd rather not inherit all of these employees. So you can't get out of TUPE by simply contracting out of the provisions. However, incoming and outgoing employers can agree to apportion risk and financial costs of TUPE between them. You know, who will pay for redundancy, for example? On one of the last transfers I worked with with a huge transport company, part of their agreement with it was a change of contract. So, you know, let's say, just for argument's sake, they were doing all the deliveries for Marks and Spencer's, and that contract was lost through a tendering process and gained by a new employer. They had lots of synergy, for example, with current transport being undertaken. So it amounted to quite a substantial number of redundancies. Well, they agreed between them who was going to actually pay for the cost of redundancies as part of that transfer process. And sometimes even the client, the customer itself, will contribute to that too. So there's lots you can do about apportioning and discussing risks and financial costs of TUPE. And as I said, it's through the use of warranties and indemnities. And warranties are contractual statements by the outgoing employer as to the condition of the business. So if the promise is breached, the incoming employer may be able to claim damages, for example. A common warranty, just for your information, given during the process to the incoming business is often that the information that's been provided about the transferring employees is full and accurate. And a common warranty given by the outgoing business is that the incoming business will not take any steps towards any transferring employees that could result in them claiming constructive dismissal, for example, against the outgoing employer prior to the transfer. So lots of different types of warranty may be given. Indemnities are different. They are promises to pay compensation if a type of liability arises. So whereas a warranty is a promise that one company has complied with its TUPE obligations, for example, the indemnity deals with who bears the financial consequences of any default of that or of non-compliance. So, for example, an indemnity given to the incoming business could be that the outgoing business will pay compensation and legal costs for any claims that were not disclosed as part of the ELI, the employee liability information. So all these warranties and indemnities end up being included in an agreement, and what they look like depends very much on need and the parties' kind of negotiating strengths and abilities. So another thing to think about. And then lastly, before we have a break, I just want to talk about insolvency. So there are insolvency provisions contained within TUPE which modify all the normal rules that I've been telling you about, but they don't exempt insolvent companies from the regulations completely. And there's two different kind of sub-regimes, really, depending on the type of insolvency proceedings. Again, this is quite complicated, and I'm only going to give you a very surface level view. So for insolvent businesses that are transferring as a going concern, the automatic transfer of employees still applies, but some pre-existing employee debts will not transfer. And it's also possible to agree certain changes to the employee's terms and conditions, provided that particular specific processes are followed. The liability for redundancy, notice pay, and some other payments to employees will not transfer to the incoming employer. Also, if it's agreed with a trade union or employee reps, terms and conditions of employment can be changed if the change is designed to save a failing business without the need for one of those ETOs, economic, technical, or organisational reasons. So basically, the idea that there's a softening or an adaptation. And the idea is that companies will be more inclined to rescue insolvent businesses, thereby safeguarding employment where the inherited liabilities, are not quite so onerous. Secondly, in liquidations, the protections offered by TUPE are watered down even further, and the automatic transfer principle doesn't apply, and employees do not benefit from any special protection against dismissal. So it's different whether it's a going concern and in liquidations. So again, if you're involved in those issues, get very good, specific advice on them. Okay, so it's 10:10. I promised a break on the hour. We've gone slightly over, but it was logical to do so. Let's take a 10-minute break. Come back at 15:15. Hopefully that's long enough for people to grab a coffee, have a quick comfort break, and I'll see you in 10 minutes. Thanks very much. So, welcome back, everybody. Hopefully you had a chance to have a quick break. So we're going to leave the legislation of TUPE behind us. But before I do completely, one thing I'm often asked is, when is a change to different employment terms and conditions permitted? So imagine the scenario, it's a bit like it's similar but not the same, apples and pears. We've transferred this group of people. They have slightly different terms and conditions. We want to harmonise, make some changes. When is that permitted under TUPE? Well, following a TUPE transfer, this is obviously a common scenario where change is desired to harmonise differences, and that's often to ensure equality between two groups or just to streamline the administrative burden. But the starting point under TUPE is that any variation to a transferring employee's contract is void if the sole or principal reason for the variation is the transfer. So let me just reiterate that. Any variation to the transferring employee's contracts are void if the sole or principal reason for the variation is the transfer. And this is even if the employee agrees and consents to the variation. So in practice, changes which benefit the employee, which are better for the employee, or those which are broadly neutral, are unlikely to be challenged. So, fall into the let's not worry about them category. However, changes which are negative are of course likely to be more contentious, and the employee will be entitled to rely on the terms and conditions they had with their old employer. In fact, where change is made, and I've seen this scenario where employers have said, okay, we want to remove that benefit, but we'll increase your salary a little bit. We want to do this, but we'll give you that. So there's an attempt to make the detriment, more attractive in some way. I've seen employees at a later point able to cherry pick terms, meaning they choose which of the old and new terms that they prefer and then seek to rely on those. So even where there seems to be, employee consent, or you've tried to balance out the change, it's still void and the employee can go back and rely on original terms and conditions. There are limited circumstances where a change will be permitted after the transfer. So let me run through those for you, where change is possible. So firstly, the reason for the contractual variation has to be entirely unrelated to the transfer. So you can still change things, but it can't be by reason of or related to the transfer. Secondly, where the variation is favourable to the employee, you can do that, as I've said already. Thirdly, the terms of the employment contract, if they expressly permit an employer to make variations, then you can make those variations. So, for example, if there was a mobility clause in the contract, you can take advantage of that. And then if there are changes to the terms incorporated from a collective agreement, that's a negotiated agreement with a recognised trade union, provided the variation is made more than 1 year after the transfer, and the changes leave the employees in no worse position overall, then that is one of the limited circumstances where change is permitted. Obviously, that only applies to those with a recognised trade union and negotiated collective agreements. And then if the change is made for an ETO reason, economic, technical or organisational reason, and also entails changes to the workforce, i.e. the number or the job roles, and it's agreed by both the employer and employee, then you can make the change. So there has to be an ETO entailing changes to the workforce that's been agreed. Where there is a change to the place where the employees are employed to work after the transfer, that's deemed to be an ETO reason. So our business isn't located in that part of London, for example, it's located in this part of London. Well, that's a change of location permitted. And then finally, if the transferor is in administration and the modified TUPE rules I've spoken to you about apply, then again, changing terms and conditions is possible. So the basic point is you can't do it, but there are some limited circumstances where you can. And we're back to this ETO issue again. So I thought it'd be worth just expanding on that very slightly. What is an ETO reason? So we know that you can make valid changes to terms and conditions, provided employees agree to them if there's an ETO reason, which entails changes to the workforce. So this requires the existence of a clear link between the contractual variation proposed and other changes to the numbers or functions or workplace of the affected employees. A change to the place of work is an obvious example that would be permitted. If there is a general reorganisation of the entire workforce, the ETO definition is likely to be met. So an economic reason might relate to the profitability or market performance of the new employer's business, which might need cost saving to result and redundancies to follow. So that's easy to understand. A technical reason might relate to the nature of equipment or production processes or increased computerization and so on, which again might change people's ways of working or the number of employees you need to employ and so on. And an organisational reason might relate to those restructures, to the management or organisational structure. And again, that would be one of the reasons that you could rely on if you needed to make changes. And in 2014, TUPE brought in some further changes which potentially make it easier for employers to effect change, where the contract allows for change, such as the application of a mobility provision, or where the employer and employee agree the change, where the sole reason is the ETO reason, and where there's a change of location. So some of those allowed reasons for change were brought in 2014, where we saw a few amendments to the TUPE rules. So it is possible. You need to be careful, I think would be my summary. And if you've got an ETO reason and that entails changes to the number of employees that you're employing, for example, then change is entirely possible. Okay, moving on. I just want to touch on restructuring a little bit more. It's a general term which employers use all the time. And basically, restructuring covers situations where staff are going to be organised differently. Sometimes that results in redundancy and downsizing, and sometimes it doesn't. So after a TUPE transfer takes place, if redundancies are required, then all the normal redundancy processes must take place. And then if the new employer needs to relocate a business or part of the services to a different location, or, you've got too many staff now, as long as there is a genuine redundancy situation that ticks the ETO box, changes the workforce, then redundancies can be made. Generally, employees are protected against dismissal, as you know, if the dismissal is because of the transfer itself. Obviously, if it's a genuine redundancy situation, as I've just mentioned, then that's fine. You can go ahead, and the normal redundancy processes must apply. So it's really important to hit all the TUPE obligations as well as the redundancy obligations. And, you know, if the redundancy situation involves 20 or more dismissals, then collective redundancy obligations will also apply. And that's all about trade union reps and employee reps and consultation. You can actually start consulting about redundancies before the transfer takes place, as long as you've got the current employer's cooperation. So they can take place in tandem, in parallel. A common TUPE pitfall is that when acquiring a business, the new employer might say to the old employer, can you just make some quick redundancies before the transfer? That's because the incoming employer doesn't want the hassle to do it itself. And the outgoing employer might be prepared to comply in order to secure a deal. The problem with pre-transfer redundancies is that for it to be fair, the old employer has to have an ETO reason entailing changes in the workforce, and the reasons mustn't relate to the transfer itself. You know, if you say I made a few redundancies to make my business more attractive, well, that of course isn't going to be a fair or appropriate. So pre-transfer dismissals can be automatically unfair, or, you know, if they're genuine and they're genuine redundancies and there's the ETO box is ticked, then that might be fine. Liability for any claims of premature dismissal will pass to the transferee under TUPE. And in many cases, the best course of action is for the new employer to take on all the transferring employees and handle the redundancies itself, with maybe some kind of agreement, warranties and liabilities, as we spoke about earlier. So the new, indemnities and warranties. So the new employer might negotiate for the cost of those redundancy payments to be paid for. But of course, proper redundancy processes must follow. The new employer must avoid, you know, methods that give their pre-existing workforce an unfair advantage too. So often in a redundancy situation, imagine a group of people transfer over, and we're the finance team, and now we've got way too many people in our finance department. We need to make some redundancies. Well, knowing that you've worked with a group of employees for some time, you must make sure that that pre-existing relationship doesn't have an unfair advantage and disadvantage transferring in employees who aren't as well known. And considering that most redundancy situations are assessed on a kind of matrix, you know, skills, qualities, performance assessments, you know, all those kind of things, if you don't know the people transferring in, it does create to some extent an unfair disadvantage. So it can be really difficult where line managers are making assessments with people that they don't know very well. So this is where consulting properly, due diligence and so on is really important, because we have to make sure our selection methods and selection criteria reduce that kind of perceived bias and unfair advantage. So redundancy can be quite complex where you've got transferring in employees that aren't well known. Okay, other practical points regarding the changes to terms and conditions. If you want to change contractual terms after the transferred staff have come across, your best options, if you have no ETO reason and you know none of the things I've spoken about apply, the best thing to do is to wait. You know, changing contractual terms of transferred staff immediately is very likely to cause difficulty if you haven't got a fair reason to do so. The longer time that passes since the transfer, the less likely the changes will seem to be linked to the transfer. In saying that, there was a case not so long ago where the Employment Appeal Tribunal held that the link can still be there after 3 years. So I would be very careful if you think about just waiting a while and then doing it, you know, again, get some advice. Red circling is probably one of the common options. So imagine the incoming staff are earning more than your current employees. Well, red circling, i.e. no further increases, freezing pay, in other words, is a really common step following TUPE transfers. So it involves freezing the pay for the employees who are higher paid until their fellow employees doing equivalent work, you know, kind of catch up and get to the same pay level. So you've got an option to wait, you've got an option to red circle. The other option sometimes followed is called firing and rehiring, dismissal and re-engagement. Employees use this strategy in many circumstances, not just TUPE transfers. This is where the employer terminates the transferred employee's contracts of employment by giving notice and simultaneously offers re-engagement on the new terms that they prefer. The legal analysis for this is that there is still an automatically unfair dismissal, and there is now a whole statutory code on this dismissal and re-engagement process. And that comes into effect on the 18th of July this year, this statutory code of practice. So employers will be liable to the code for processing or starting those kind of changes on or after the 18th of July. So study this route carefully if you wish to use it, and again, take some good advice. It may be possible, but I would certainly give it a decent amount of thought before embarking down that road. Because some claims for automatic unfair dismissal can be made without 2 years continuous service. And I'm sure you're aware that you normally need 2 years continuous service to make a claim of unfair dismissal. For example, where a dismissal relates to flexible working or even the working time regulations, you know, you don't need to have 2 years continuous service. However, TUPE claims are slightly unusual. A dismissal for a TUPE-related reason is still potentially automatically unfair, but does require 2 years qualifying service. So, you know, there is a difference there. It's possible, but there is a difference. And many employers in a dismissal and re-engagement situation will want to, you know, tread carefully. But often employees, to be quite honest, want to keep their jobs and will accept new contracts without a fuss. But other employees who have 2 years qualifying service may wish to bring a claim. So there is a risky strategy. Settlement agreements might be an option. If employees wish to leave after they've transferred, settlement agreements are a good way to prevent any future tribunal claims being brought by an employee, but they cannot be used to vary transferred employees' contracts, as that's not permitted, and TUPE prohibits agreements that exclude or limit its operation. So again, there might be some use of settlement agreements, complex area again. You know, have a think about it, take some advice if that's what you want to do. Okay. What I want to mention now is where changes to terms and conditions are not possible. So we want to harmonise, but we know we can't, or we can't fairly do that or legally do that. So we've now got groups with working together on different terms and conditions. So where change is not possible or not actioned, integrating transferred employees into the new workforce, creating this kind of one team culture that everybody always wants, can be quite challenging. You know, imagine some employees get really good sick pay or much higher wages for doing seemingly the same or similar work. Or some get the option of time off in lieu instead of overtime. You know, all these things are likely to impact morale, cause employee relations conflict to some extent, and makes it harder to integrate people post-transfer. After all, people talk, and eventually these differences will be known. And I find that often employees just aren't familiar with the protection that TUPE gives, especially the employees where they didn't have any change. So employees that transfer in will be pretty versed in what TUPE means to them, but the employees that they join often don't have that same amount of information. They're just not familiar with what the legal rights and obligations are. So I think one way to alleviate this situation is to provide, transparent, good information regarding TUPE, what it means, what protection it provides to help the integration process. For example, it can be quite broad. You can simply explain that there are contractual arrangements and that businesses are legally prevented from changing terms and conditions following a TUPE transfer. So there may be some differences between you. And this will hopefully help employees understand why their colleagues are seemingly being treated differently to them. Where two groups of employees are on different contractual arrangements, there's obviously that risk of somebody feeling undervalued in comparison with their colleagues. Why aren't you prepared to push my terms and conditions up? And that's mostly likely to apply where the significant difference relates to pay. So, paying more attention to ensuring that all employees feel recognised and valued for the work they do is really imperative. I know recognition can be as simple as saying, thank you and giving some good feedback. But, if we're going to do it, let's make sure it's really well done, specific and meaningful and timely and authentic. Just saying regularly to people, thanks for your hard work isn't exactly motivational. So you have to do the best you can. But I would say, information, making it clear that this is a contractual legal obligation, and then honing in on the positive people management side, making sure people feel valued and respected and recognised for what they do is probably the best you can do in those circumstances. If you can afford to increase and alleviate some of the difference, of course, that's a great option, but not all employers financially would be able to do that. Okay, so that's kind of the legislation bit done. And this webinar is also about the people, the human aspects of mergers and acquisitions as well. So we will focus in on those in this next section, just to make sure that you don't become one of the 70 to 90% don't meet expectation or failure. And as you can see on that example there from the Harvard Business Review, poor integration, ineffective communication, cultural clashes, all things that we can do something about. So let's move on to that section. I mean, looking at those stats for a second, I think it's really high to say between 70 and 90% don't quite make it across that kind of finish line or in the successful way that was envisaged. And I think it's really high. After all, these are calculated moves made by business owners and leaders who've looked really carefully at what they want to do at the deal. So it's not just about number crunching or gaining new customers or operational efficiencies, where there's a myriad of other factors that contribute to what can go wrong. And often people, when I've spoken to employers that have been through TUPE transfers and interviewed, executives and leaders of those organisations, they often point out that the cultural differences and the communication barriers and the way that people work is a significant challenge. And of course, those things lead people to leave. And most organisations, are reliant on their employees and what their employees can do for them. For instance, management involvement or lack of plays a really critical role in whether an acquiring company successfully integrates the new employees into its operations. All too often, I think deals are struck without considering some of these clear integration issues that have to take place post merger or acquisition to get people to work effectively together. And a linchpin of this, of course, is planning and communication. A clear communication plan helps minimise the uncertainty during these periods of change. And that's what we're talking about, change management and minimising uncertainty. Because when employees feel valued, included, involved, knowledgeable, know where they're going, know what's happening, they're far less likely to feel that kind of mistrust and want to look for, greener pastures. Also, size isn't always a predictor of success in the mergers and acquisitions world. In fact, it's the larger deals that often face more challenges than the smaller ones. And this is often because of complexity. You know, a merger or acquisition involving, you know, thousands of people isn't just a financial transaction. It's like merging two universes with their own planets and stars and, you know, laws of physics, if you like, of such enormous scope for risk of miscommunication, misunderstandings, you know, missed objectives, goals, timescales, all those things cause friction. Even integrating HR systems and processes can be far more difficult than anticipated. And that's why the bigger the deal, the more important it is to have a team dedicated to how this is going to run as a project. You know, trying to shoehorn all this additional work into someone's already busy day job is very, very difficult to do. And I would also say that failure isn't permanent either. You know, it might not be as good as you wanted it to be, and many businesses fall into a rough patch post-merger and acquisition, but do eventually emerge stronger than before. So sometimes there is a pain threshold to be overcome. So knowing how to address problems that arise can turn eventually obstacles into successes. So lots to consider. When the problems are likely to start, well, I would say early on, as soon as the merger or acquisition is rumoured, focus often shifts to the big event, and management get tied up in meetings and negotiations and all the mergers and acquisitions piece, which sometimes mean day-to-day operations and people get neglected. People then start to feel wary. People start to feel threatened potentially, and sometimes that's when, you know, we lead to the excuse me, the possibility of losing good people. Just have a sip of water. Thank you. So right from the word go, I think we need to start planning how we're going to manage people, manage the process, and as well as look at post-acquisition. Some of the common mistakes I've seen when it comes to HR and people management is, you know, the employee engagement or lack of. All too often, the people that we're going to rely on just don't get involved enough, aren't spoken to enough, aren't, you know, part of the change process. That means that they have insufficient or, you know, a lack of decent communication. When change follows, how do we manage that whole change process? All the research says, you know, if you imagine change as a cycle, the earlier people get involved in change, the more likely they are to support rather than abort whatever changes they need to do or make in their day-to-day. Culture, we've touched on already, and I've got a bit more to say about that in a little while. And then differences or complications in the whole reward, recognition, benefits, bonuses needs to be ironed out. And then making sure we've got leadership alignment. I mentioned at the beginning that I literally just finished working with an organisation where all their problems have come from complete misalignment with their senior leadership. They had a chief scientific officer who had an entirely different way of working to the chief executive, and the CSO came as an incoming person from the transfer, and the CSO was the current employer. So even you know, two people in conflict had a huge difficulty that just filtered and diffused through the whole organisation. Think of a merger and acquisition as basically a huge change management project involving people and legal complexities. It needs to be properly planned and managed. Because change is inevitable and change causes discomfort. And some people really want to resist change right from the start, you know, and that moves to periods of confusion and chaos and concern. But eventually, with hard work and a good plan, we can end up with an improved state of operations. So the more we plan, involve people, steer the process, communicate, the more that journey will be as smooth as possible and the outcome the best we can have. So whether we make a big change or undergo significant transformation, it's well known getting people involved from the start and listening to them will get you the best results. And people often want to minimize the dissenter. Let's not hear the negatives. Let's quieten those people. And I think the exact opposite. Let's get everything out on the table as early as possible so we can actually understand what causes concern, conflict, difficulty, and do something about it. It's like plugging a volcano. If you try and seal that up so we don't deal with it, we don't need to hear about it, maybe it will go away. Ostrich management syndrome. Eventually that plug is going to, blow, the pressure will build. So engagement needs to come early, needs to be authentic, needs to be genuine. If relevant people get involved from across your organisation at every stage of the change process, even from understanding the rationale and reasoning behind what we want to do, behind any new initiatives, behind any challenges, recommending and planning improvements and implementation will give you by far a better chance of success. A workforce filled with people who feel like they have to implement change or agree or adopt new initiatives is going to be nowhere as successful as one that's filled with people who understand the need for change and want to do it and make it happen. And that's far more a formula for success and improvement. So remember, appeal to the heads and the hearts. The head, logic, data, reasoning, good information, and the heart, how people feel, what they want, what it would be like to work in this organisation. So always remember that when you're planning, what do we need to do to appeal to the heads and the hearts? Put hard data behind organisational decisions. It's really smart. But when you get success from change, you need more than that. You want employees that are inspired, that are on board, that understand, that have bought in. So you have to dig a little bit deeper when you communicate those kind of changes to employees. If we just say, oh, from now on, we're going to be doing this differently, that differently, and the other, and this is the impact it will have on your jobs, people, it's no wonder they resist. So we need to share far more and involve people. This is all about management and leadership skills. So we need technical skills to make and manage projects well, and then the leadership skills to communicate those visions and inspire and empathize with people. So management and leadership have to go hand in hand when it comes to TUPE transfers. One I always think is good to remember, and I don't know whether any of you will have read about this or seen it at the time, is where the software company Oracle acquired PeopleSoft in 2005, which led to more than 5,000 job losses. And the vice president for HR said, uncertainty is the biggest killer of morale and motivation, and speed is the single most important action in a merger or acquisition. The sooner people know where they stand and what their role will be in the combined entity, the sooner they can direct their energy into serving customers rather than worrying about their future. And I think that's really, really, really good advice. Uncertainty is the biggest killer of morale and motivation. Speed, the single most important action. So plan what needs to be done, when it needs to be done, who is going to be doing it, how it's going to work. Speed is of the importance here, with all the changes at once being understood. There's something about the drip, drip, drip attitude to change. It's like a torture. One thing changes, there's a gap, we let people settle down. Now we need to do this, something else changes. It becomes expected eventually and really disruptive. And people end up with that change fatigue and resistance and even resentment. So I would think carefully about let's spread the change out over a period. Of course, there's the other problem where you flood people with a ton of change and it feels like a tsunami. We don't want people to drown, but we need to have a proper plan that doesn't draw things out, because that leads to more uncertainty. So key takeaway, focus on time and focus on, certainty. So we make sure that we give as much information as possible. remember years ago working with a broadsheet newspaper, and they were bringing in some changes to their sales process. So the people that sold advertising in this broadsheet, they wanted to improve their outcomes and on their sales. And when they spoke to the sales group, lots of people, they said, what's the biggest resistor you get, when you're trying to sell space? And they all said how much it costs, because we're the most expensive place to put an advertisement if you want to advertise in a newspaper. So what they decided to do was to bring that to the fore of their sales pitch, if you like, and ended up saying something like, make a phone call. Hi, my name is so-and-so from whatever newspaper. I want to talk to you about advertising. And at some point in their conversation, they would say, look, I can tell you that we will be the most expensive place that you could put your advertisement. I can assure you we'll be the most expensive place. And there's really good reason for that. And that is because we've got the greatest readership. The average earnings of our reader is X. We're seen by more people than any of our competitors. So instead of trying to hide the difficult bit, they turned it on its head. It's like saying, let's talk about the elephant in the room. You take away the sort of power of that conflict when you bring it to the fore. And I think if we've got big change to come, and it's not all going to be great for all people, the better it's managed, the less the more transparent we can be, the sooner, the better. Because fear of the unknown is often what makes people feel even worse. Essential people management, we've talked about a little bit of this already, but managing people really well before, during and after the merger and acquisition is obviously a given. People are a real business risk, whether that's, the classic drops in productivity because we've taken our eye off the ball. Often the excitement of all this change moves to a less than perfect reality, moves to disappointment. And if it does, then this is where we might end up at risk of losing key talent. And often it's the best that go first because they can. It's easier for them to do that. That then causes instability and often results in recruitment difficulties too. You become far less attractive as an employer if you're seen to be in a slightly downward spiral. And finally, without a focus on people management, we also see, an enhanced cultural clashes and difficulties, which further harm and, hamper good performance. So that's the reason why we need to turn up our focus on people. I think companies preparing for mergers and acquisitions often give so much attention to the hard business deal and not enough attention to the people and their human resource. That sometimes people management and workforce planning actually gets left until a later stage. But to succeed, I think we need to pay really close attention to the softer human side of mergers and acquisitions. When people start, when managing people, I think we should definitely come from a place of empathy. And if you manage people through a merger and an acquisition, I think try really hard to put yourself in their shoes. I know it's difficult to do because you have information that they may not have. But if you can try and see it from that person's place, the ability to do this and understand someone else's situation, challenges, concerns, fears is a really powerful trait to have. It also will shape what you say and what you do. So I think understanding your colleagues' feelings and goals and fears will really help you structure how you manage people more effectively. It might be that your job is safe, but you're about to embark on a redundancy program that puts them at risk. It's got to change how you approach managing people. Employees in organisations that are acquired or merged with other organisations always report lower overall satisfaction, because normally there's lower trust in new management that's not known, and a diminished sense of job security compared to employees in organisations that haven't been involved. Now, that doesn't necessarily have to last a long time, but it's really, really common. It's nearly always the case. So that leads to people feeling, less flexible, less adaptable. less autonomy, less self-management. People become more rigid, more defensive. There's more stress. You know, all these changes are a result of how people feel when there is lower satisfaction and lower trust and a diminished sense of job security. So we've got to recognise that that's very likely and manage for it. You know, how do we get round low employee morale? How do we improve commitment and cooperation? You know, what can we do differently? So start with employees. Don't overlook the importance of this. You know, we need to go back to what are our plans? What will be our communications and messaging? How are we encouraging and engaging our workforce? How transparent and open can we be? I mean, there's nothing worse than saying everything will be fine, and then 3 months later, you start your redundancy program. So we need to have that kind of honest and effective approach to people. And leadership is all about, you know, making sure we bring people with us. It all comes down to outstanding leadership. Let's face it, in periods of change during mergers and acquisitions, you know, we really want people to come with us and embrace what we need to do. We need buy-in and action and positivity. And while there's no one right style for every change management scenario, we should come from a place where people understand the rationale behind it, as well as the impact, before we can try and get their buy-in. As I said before, people rarely complain that their manager spends loads of quality time with them, gives them great information and feedback, holds regular team meetings, listens to my questions and answers them. You know, people don't complain about that in mergers and acquisitions. They complain about the polar opposite. So where you do a certain amount of communication and one-to-ones, I would increase that. In my view, the kind of democratic leadership style is the best place to start. And central to democratic leadership is the desire to listen to all voices, concerns, answer questions, and have everyone contribute, if you can, to decision making. You know, foregoing formal hierarchies to some extent to facilitate more teamwork and collaboration and participation is what the democratic leadership style is all about. If you fall back to a very autocratic, top-down leadership style, you'll enhance the way those people are feeling negatively rather than decrease that. So, you know, democratic leadership, you know, is leading change, taking an approach to ensure that people feel heard, included, engaged, working as a team, implementing lots of we change and initiatives is really important. This type of leadership, I think, is a real asset when it comes to mergers and acquisitions. However, where things go off the rails with this democratic leadership style is if we want to include absolutely everyone in things, in decision making, and do that all of the time. And as a leader, you'll know that there are times when unpopular or quick decisions need to be made in the company's best interest, which won't be with the input and agreement of, you know, direct reports. You know, the need to downsize or reorganisation is maybe an unattractive decision, but a necessary one. In pursuit of your desire to include everyone, sometimes the democratic-only leader can slow things down or overly complicate implementation of change. So a balanced approach is obviously needed. So when I say I think a democratic leadership style is a good place to start, of course, you know, you may have to do things differently as well. Sometimes I think if a decision has to be taken in the absence of some people because it's, you know, such a senior point or, you know, it's something that we can't share at this point, then take time afterwards to explain why. You know, if you can't communicate at the time, communicate later. People understand some things can't always be shared. And we're going to talk more about communication shortly, so it's probably a good place to stop here because, you know, in my view, communication is absolutely the linchpin to successful change. So this is a good place to stop before we move into a new category. It's about 11:05, so let's take another 10 minutes, come back at 11:15, and we'll deal with the last couple of sections at that point. Okay, thank you very much, everybody, and I will see you at 11:15. Thank you. Welcome back, everybody. I hope you had a quick break, and last couple of sections of our agenda now. So as I said, we're moving on to look at communication. And this is where, in my view, the charismatic leadership style, hand in hand with the democratic leadership style, can be really effective when it comes to communications. Charismatic leaders really rely on their communication skills and referent power to influence, persuade, and inspire those around them, that the change can be beneficial and enable them to buy into their future vision. And they often lead by example as well. I often find that with the real charismatic leaders. And their positivity is really infectious, just in the same way that, you know, negative people are really infectious and bring people down. Those charismatic leaders really make others trust and want to follow their lead. And they also are really capable and able to engage people using storytelling to kind of paint pictures of why the change is needed and what the future looks like, and make it really easy to understand. And I think that's a great advantage. You know, I talked a bit about head and hearts. Often we bring people with us when they, you know, when they want to, they get sucked into that kind of story about the future. In addition, that type of person also reads their audience really well and is often able to adjust their approach, slow down and focus on areas of more importance, you know, speed up and deal with areas that, you know, people already understand differently. And really work off the responses that they receive. And people are often really willing to speak up and talk to that kind of leader as well. If you're very distant, not very visible, not very inclusive and collaborative, chances are people aren't going to bring their concerns to you, and they'll make their, you know, their views known by walking rather than talking. So I think using that kind of style, upping those kind of behaviours, is really helpful and really important. You know, this ability is really crucial during the integration stage, where individuals start to, you know, understand and incorporate change into their day-to-day. However, no change initiative will survive if the strategy isn't sound, or if the implementation process and contingency planning is not well thought out. So you can sell it as well as you like, but if in the reality it doesn't work, then, you know, you're going to fall back to that position every time. So just to round off that leadership styles, think democratic, think charismatic. One thing that I always say to people about communication, and I do, you know, communication webinars of all different types, is that, you know, communication before, during and after the transfer is obviously essential. Don't just wait until after it happens. And that needs to take place not only with transferred employees, but with the whole existing workforce who may be impacted by the change too. So share information as early as possible to help people adjust and familiarise and increase your chances of that smooth transitioning. You know, I think we should make sure that you're meeting regularly, not just sending out written communication, but meeting regularly with employees to discuss the transfer and, importantly, ask for and answer questions. I think it's very wise to listen to employees and be able to provide, you know, constructive feedback or information that's useful about the transfer. Meaningful employee engagement will really optimise the success when it comes to the people part of this process. I also think where you're communicating quite a lot verbally, it's really important to keep a written Q&A too, because not everybody will be at the meeting, not everybody will remember what was said. So having an ongoing, that's built Q&A divided into topic areas to make it simple for people to find questions and answers is really helpful, especially if someone might forget something. Or, as I said, you know, not everyone's in the meeting where things were discussed. Recording meetings is another great option as well. It just allows for that consistency in messaging and avoiding, you know, miscommunication. Because I've seen miscommunication, you know, spread like wildfire around an organisation, especially when you get it from someone who sounds so knowledgeable. I get this all the time where people will say, well, I know, you know, something, and they'll present it as a fact. Well, a good one is, I know you can't give a bad reference when it comes to employment references, And some people will present it, you know, so positively that it's believable. So, you know, let's get what we're going to communicate and how we're going to communicate right from the word go. And communication obviously is the process of transmitting information from one person to another, but that's not where it ends. For the transfer to qualify as being successful, the recipient must understand it in the way that the information was meant to be understood, that it was intended to be understood. So, you know, it's not just getting the information across, it's making sure it's understood as it should be. In other words, it's also two-way. So think verbal, speaking, listening, think written, reading and writing, and think visual, how we come across, what our body language says about what we are communicating. So when it comes to TUPE, often the communications are coming from people that are not known to everyone, that might be from the new employer. So you have to focus even more to ensure that you get the message across in the way that you intend to, and that the understanding is as you want it to be, and that you minimize the kind of suspicion that comes often with new people or other emotion. And we want to make sure that we don't change the interpretation of the communication given because of the way we feel. I'm sure you've come across this yourself. When somebody has a difficult relationship with someone and they get some emails from that person, I've heard people read an email out in the most negative way possible because of how they emotionally feel towards that person. If I read the email without knowing that there was any conflict, I would read it in one way. The way that person reads and interprets it is far different because of how they feel. So bearing in mind that people will feel some sort of anxiety, that's really common with change, have some sort of suspicions. You know, if I feel suspicious and I hear someone say, don't worry, all is proceeding as it should be, you know, I could take that as the words that are said, or my mind could twist that and say, don't worry. Why would you say don't worry? Why say don't worry at all? Why not just say everything is as planned? You know, what you're trying to, why are you overemphasizing that I shouldn't be worrying? Do you see what I mean? People start creating what isn't there. What does this really mean? You know, instead of saying don't worry, which is like telling someone to calm down, you know, the second you tell someone to calm down, that normally has the opposite effect. You know, leave out those words. You know, instead of saying, don't worry, everything's going to plan, I would say, I'm really pleased to report that everything is on track and we're proceeding as we planned. You know, there's nothing to feel negative about there at all. Don't worry, that outfit doesn't make you look fat. You know, whoever then thought they looked great. So, you know, try and avoid those kind of additional words that may not be necessary. You know, instead of saying, don't hesitate to contact me, say, I'd love to hear from you if you have any questions. So let's try and take any sort of don'ts, because they have that negative twist that some people will put, and let's keep our language in the positive. And the other thing I'm always, you know, really keen to stress is that well, when we're talking about communication, for any effective communication to take place, there needs to be some communication. So it needs to happen. There's a common saying, you'll have all heard it, no news is good news. Well, I'm not sure I'm a subscriber to that. What that means is what you don't know won't hurt you. And that's a pretty disastrous approach, I think, for companies in change, as no news is usually interpreted to mean there's probably bad news coming, or there's bad news, or there's bad things going on. So at first glance, the phrase is slightly perplexing. You know, after all, the absence of negative information is a good thing. But, you know, as I said, while they might hold true in some circumstances, when people are fearful, silence becomes quite deafening, worrying, and sometimes really isolating. I did a big communication piece on a merger and acquisition fairly recently, and we decided to hold meetings twice a week, town halls and then team meetings, whether there was anything new to report or not. It became a standard. So there was always the opportunity for people to ask questions, even if there was nothing new to update people on. So I think it's really good practice to, you know, put some standards in like that. Consistent communication is also really important. You know, if you leave gaps, that's where speculation and assumption and someone's, you know, bit of misinformation creeps in. And especially from those not in the know, but who like to talk, they're the ones that are quite worrying. And any vacuum of information, I think, breeds a bit of mistrust and anxiety and a feeling of disconnection amongst team members. So make it regular, make it good quality, you know, make what you do and what you practice the antidote to the no news predicament. Keep those lines of dialogue open. And it creates an atmosphere of transparency, because information is going to flow both ways, remember. I always remind people of this when training, actually, on you know, giving good feedback, for example. One of the a little kind of activity I ask people to do is in pairs, you know, let's say there's 10 pairs in a room. Each of those pairs is asked to draw a house. Take 3 minutes and draw a house. The two of you have to both draw some of that house. And that's the only instruction. That's the objective. 3 minutes, draw a house. And then I walk round and I look at each one and I give some feedback. And some of it's glowing about this amazing house where I'd love to live. Some of it's really negative. That's awful. Please never draw again. Some is delivered well, some is not. But there's always one pair that gets no information at all, no communication, no feedback. And then collectively, when I say, so who wants to comment on the feedback that I gave? Nearly always the first couple to comment are the ones that didn't hear anything, because their anxiety and concern is higher, even than the people that were told that that was a really awful drawing. So no news is not good news. No news causes people to feel, you know, some level of anxiety and concern. It's also easy to forget when we know something that someone else doesn't. It's easy to forget, have we communicated? Because, you know, it's the same as when you know how a process works, you might forget that other people don't know as well as you do. So back to that, put yourself in your team members or other people's shoes and think, okay, what would be good to know? Have I communicated as much as I can? Obviously, you can't tell everyone everything, but you can tell them something without lying. And of course, you should never, you know, lie in any of these communications. You know, if someone says, what's the decision on X, and you can't yet give that decision, you can at least say, look, it is a topic of discussion. And I know I can't say much more on that now, but I will give you information as soon as I'm able to do so. You know, it's honest. People understand that there is limits, but you haven't shied away or misinformed people. I also think it's good to remember that you should leave nothing to chance when it comes to communication. The work on your communication throughout the merger and acquisition is going to, you know, ebb and flow. There'll be peaks and troughs. You know, at the announcement, for example, there's going to be a lot required of the communication piece. You'll be talking about strategic rationale. It's your first opportunity to give the vision behind the merger. You know, why it's happening, why employees should be excited about it, who will benefit, you know, what it will mean for the customer, or, you know, whatever. You set the kind of stage for collaboration and focus people on the positives. And also, you know, let's try and focus people on continuing their day-to-day and great performance in the meantime as well, because so often feet get taken off pedals at this point. You also want to be controlling merger news, responding to, you know, to questions, avoiding leaks or misinformation. And then in the pre-close period, you know, after the merger announcement, that often requires, you know, special communication attention, because this is also a time when competitors might go after customers and your top talent, who, remember, might be feeling a bit anxious and thinking about whether this is going to be the right place for them going forward. So regularly communicating at that stage in the pre-close period, I think, is really critical to limit any damage to the organisation. One mistake I see so often is companies make an announcement and then it goes dark, and they communicate little or nothing between the announcement and, you know, day one. And another typical mistake is avoiding those substantive topics and instead, you know, offering up nothing but happy talk or corporate, you know, prattle, to try and comfort people. But too much of that, and nobody will believe it, except maybe the ones that are saying it. So we need to, again, think about whether we're approaching this in the right way, right content as well as right way. It's got to be genuine and it's got to be transparent. Employees value having difficult messages communicated often in a direct way. And it's also an important time for the leadership team to look for and listen to feedback and concerns so they can reinforce what's going well, take corrective action when necessary, and deal with concerns and fears that people have. And then when the deal is done and we've moved into new co, that's a time for more communication as well, celebrating the coming together of those organisations, giving clarity and guidance, telling employees what's changing and what's not. Too often I hear employees who don't know on day one who their new boss is going to be, or what the new process for X, Y, and Z will be that they have to follow. So this is where those kind of structured communication plans have a really critical role, ensuring employees are well informed and equipped to operate, seamlessly from day one. You'll be amazed at how important it is to people to know where they fit in an organisation. Is their job title any different? Is their reporting line the same? Those kind of things are really important to people. And first impressions are difficult to change. First impressions are lasting impressions as well. So, let's make sure that we get the right senior leaders in the right locations on day one, visible and accessible during that week, coordinating town halls and written communications. I think you should always then pick up and follow up on the same day or the next day into smaller team meetings and then into one-to-ones. That kind of consistency in messaging is essential, and also bringing it down to a level which is, what does it mean to me individually? And the communication work doesn't end at that point either. In fact, more frequent communications usually come after that point. What are the changes? What's the integration? Specific messages about decisions. Key changes often occur weeks and months after the kind of legal day one. So we want people to be excited about the new company, its vision, to buy in before they, get to that point. Basic things: do I have a job? Will I have the same job? Will I have a job in the future? Who am I reporting to? Is this change good for me? Imagine what you might be thinking in their shoes and make sure you communicate appropriately. As well as kind of the time, when we need to communicate and what we need to communicate, we also need to think, a well thought out plan for different groups as well. What are the merger milestones? And who are we communicating to? What do they need to know? And don't forget to consider who is the best person to deliver these communications. Is the HR director the right person, or would the new CEO be much better? Should the head of manufacturing communicate about this, but the finance director communicate about that? So have a think about who as well as the rest of it. And don't forget to consider too, on what style that you should adopt. How formal should it be? When would we have question and answers rather than just a delivered message? I remember once on one particular merger and acquisition, completely forgetting about the retiree population. And we were flooded with, concerns about what this meant for pensions and post-employment benefits and, all sorts of things. So, remember too from our session on TUPE that there could be collective consultation issues with reps for current employees as well as others in my example. It's so tempting when you're communicating to just, stop listening effectively. When you've got messages that you need to give, but you're also listening to questions, you have to really pivot and plan for change, I think. It's really tempting to hear a few words or sentences from someone and then make a decision as to about what this is going to be about and dive in after a few sentences. So I think, hang back a bit, try and get a full picture, give people a chance and time to speak. If we jump in too soon, that's where we make assumptions about what someone wants to say, often the question comes right at the end. So you don't make assumptions from the preamble, if you like, as to what the question might be. Seek first to understand before you are understood. And don't be afraid to ask questions if you don't understand. Also, if you hear yourself saying, oh, but I thought you would have known that, then chances are something's gone wrong. And let's go back and see whether we need to take a few steps back in our communication plan. So if you hear people saying that they don't know something and you think that they should do, then you need to check back before you plough on. Sometimes conversations in small groups and one-to-ones are far easier to be very interactive in terms of two-way dialogue. So, at what point will we be seeking questions? Are we going to ask for questions, written questions in advance? So plan for that. And also think, well, what would be the worst questions I could be asked? When you're planning to communicate, take some time to think, how will I respond to, the very worst things that I think I could be asked, given the state of where we are in this merger and acquisition. I think it's really helpful to spend a bit of time doing that and collaborate with others as well in how you would answer it. Two-way feedback is really important, it's critical. And also making sure that messages are received as intended, that gaps are flagged and addressed appropriately. And there's effort made to gather feedback so people understand that it is two-way. Feedback collection can be via a whole different number of tools. We've talked about allowing people to ask questions, but you could also have pulse surveys, integration barometers, focus groups, digital email feedback forms, for example, or question forms. Lots of ways other than just verbally hearing what people want to say that you can gather questions and analyse and take corrective action. I know that companies often use, well, I call them fire spotters, but you might call them something else. Often they're long-standing, well-respected employees who other people will speak to, and they have a kind of influencing, unofficial, informal role within organisations. Sometimes the receptionist is one of these people, or some long-standing employee that has great internal relationships. Engaging those people up front and gathering their support is really helpful as well. They can be a really credible way of that kind of barometer feedback. In a recent merger, I was involved in a couple of fire spotters quickly identified that there was a small group of really critical, talented employees that were collectively thinking about leaving. So having that heads up early, the senior leadership were able to take some kind of corrective action, brought forward some of their planned communications on future organisation structure, made some changes. And while the exits weren't stopped entirely, they made a significant, approval on what might have happened and really did mitigate the situation. So think about that as well. If you haven't got your ears to the ground, you're not going to hear it. And by the time it happens, it might be too late to take corrective action. Choose the right communication method as well. Think when it's right to put it in writing, when it's right to have a webinar, when it's right to individualize and personalize the communication, how often we should have small groups, one-to-ones, all hands, should videos be on or off, should it be in person? There's lots of different ways to communicate, and you've got to think about the message and the right method. Communication in mergers literally is the glue that holds everything together. Absolutely vital to get this right and spend lots of time thinking about it. It's one of the few kind of merger work streams that goes live immediately as soon as merger or acquisition conversations begin. Got to start planning that communication strategy and promoting business continuity, reinforcing all the good stuff. Think about location and timing too. If you're communicating bad news, try not to store that up. And invariably, it's better to do that face-to-face as well. There is a time and difficulty graph. The longer you leave something, the more difficult it is to communicate it. I've got one client that has something called Good News Fridays. So the way it works is, or if there is good news, that's the day that we're going to, publicise and celebrate it. But also, if there's bad news that comes up on a Friday, unless it's absolutely essential emergency, then it's always saved until the following week. So they really focus on creating that good vibe as you go into the weekend, and mentally people feel differently. So think about what you're saying, who you're saying it to, when you're saying it, who is the right person to say it, what's the right method, and all the things that I'm sure you would be thinking about. Another one that I'm really keen to remind people of is sometimes little and often is better. It avoids leaks and assumptions, trying to keep communications clean and clear. And, I think KISS is a good reminder. Keep it short and simple. Be concise. I've got a great colleague I work with that always says, just tell me the time, don't build the clock. And sometimes people are really keen on that, get to the point type communication. It also makes people sound confident and really credible too. Sometimes details required. I'm not saying that's not possible, but sometimes that can be given in a different way. So, here's the essence of what you need to know. Further information can be found here, or the detail can be read in this document or whatever. So, make your communications work effectively. It's a bit like a mini skirt, short enough to keep interest, long enough to do its job. Making your message easy to consume reduces the chance of misunderstanding, speeds up the information transfer, and helps make sure that people understand what it was intended that they needed to understand. Think also, instead of speaking in long and detailed sentences, reduce your message down into bite-sized points. And also avoid jargon and acronyms unless you're really sure that the audience is going to understand them. The rule of three works really well in any communication. It's a really good principle to remember. It makes things memorable, blood, sweat and tears, stop, look and listen. I came, I saw, I conquered. My three for this would be less is often more. I know that's four, I added in the often. But be, clear and direct, but not so it's rude or difficult in any way or abrupt. Okay, and then what I lastly wanted to say on communication is to check that and clarify that what was heard was what you intended to be heard. Let's avoid confusion and misinformation. Let's say there's been a town hall or an all-staff communication. Let's break that down afterwards. Make sure you have those team meetings and one-to-ones so people have a chance to talk about what's been said, because often the Q&A in town halls or all hands isn't possible, or people feel uncomfortable and don't want to raise questions. So, let's make sure we filter that down. People also say yes on a scale of 1 to 10. If you say to someone, well, that's what I wanted to say, does everybody understand that? And they all go yes, you'll know better off as to whether people understand it in the way you wanted them to. You've just reinforced that they've heard it. So instead, it's test their understanding. When you have the next one-to-one, say, you were at the staff meeting, you were at the all hands, tell me what you took from it, or what do you think were the key points? Let's make sure we understand that everyone has heard what was said in the same way. Just taking a few minutes to do that will be so important to you, because when someone gets one thing wrong, as I said before, that can really spread. And lastly, let's inject a bit of enthusiasm into what we say. Really think about how you come across. It's much more infectious and easier to hear where there is some sort of, enthusiasm and passion and, love for what someone's doing and talking about than there is with a very monotone, sort of boring presentation. You have to humanize the message, address what people really care about or need to know about, and try to avoid too much formal logistic communication as well. Okay, and I've just put up on this slide just a few common communication complaints. And if we follow the kind of steps that we've talked about already, I think you'll avoid all of these issues. So it's just a summary of some of the things I've been talking about to you already. So don't forget to be welcoming. When you've got new people joining your team via a TUPE transfer, it's really important to spend some time helping people settle in, getting to know them, appreciating it's a stressful, uncertain time. This is where HR and LAD, learning and development teams can pay a lot of attention to onboarding. Don't even wait until day one to engage with new people that are coming. So what can we do prior to those people joining us, and also when they first arrive? Have a plan, for their onboarding. It will all help no end to, how someone feels and how quickly they integrate into the team as well. And when onboarding, apart from all the practical stuff, like where they're going to sit, have they got equipment, what's their new email address, or any of those things, remember to share company's values and missions, help the acquired employees understand the heart of the organisation as well as kind of the practical stuff. Make sure people understand how the performance review process works right from the word start, the word go, so they'll know what will be evaluated, how it will be evaluated, what it means. Career goals are really important. People don't often just want to know about the now, they want to know about the future. Calm worries by having some career planning as part of the onboarding process, if at all possible. And also make sure you've got those common and frequently asked questions. And this should all be done in advance, so you're able to say, oh, this is the answer, rather than endlessly, I'll find out and come back to you. Takes the stress out from anxious employees a little bit. And remember, you're bringing people in. So induction, first 100 days, for example, is a really good thing to do. Arrange for, introducing them to other people. What are the health and safety issues they need to know? What policies and procedures are different? How their role sits in the organisation? Who are the key people that they need to be familiar with? That induction all helps employees learn where things are, how things work, who they need to speak to about what. It helps achieve that difficult balance between, you've got to welcome them as into your company, but they're not really a new employee because they've got long, sometimes lengthy service. So respect their knowledge and experience and expertise, but make sure you cover off and welcome them into the new organisation. And one really good way to do this is through buddying and mentoring programs. It's really, I've seen it work so well in mergers and acquisitions. It's a great way of supporting the integration of transferred employees, where you connect an acquired employee with a mentor in the organisation. It really helps on the culture piece as well. Gives a really solid foundation of in a friendly way as well. It's a really good thing to do. And think about the physical work environment too. Where are we going to actually sit people that will help integration and collaboration as well? That's if they're not fully remote, of course, which will be different again. And then help employees develop relationships with their new colleagues by creating opportunities to meet as a team, whether that's team meetings, group project work, coffee dates with colleagues. Social events are really good too at the beginning. If you're creating new teams, what about some team building, some joint training, enable those working relationships to develop much faster and better. Team building activities are a great tool for developing a one-team culture as well, especially if you're remote working. Find opportunity that you might not have had already. And this all builds culture. And I think culture is that kind of difficult thing to explain. It's what it looks like and feels like to work here. It's the vibe in the workplace, how things happen formally as well as informally. It's kind of that mix that shapes the experience someone has when they work in a particular workplace, how things get done. One definition I really like is that company culture is the personality of the organisation, and it's made of many threads kind of woven together. So let's think about the culture. Let's understand where the differences are, because often it's very implicit. People who share in a culture find their culture challenging to recognise sometimes. If you say to someone, what's the culture like? It's really difficult to pinpoint and be really clear about that. Often it's outsiders that are all more kind of insightful than we are when we're involved in it. So, you know, culture is also quite resilient because it comes from often long-standing employees or ways of working. So there's some, you know, the resilience of culture. It's difficult for people to see what influence it has as well. So when you come to culture, you know, we really need to think about all those different, you know, layers and strands that make that up. And a shift in leadership style can generate, you know, turnover of among employees who object to the change. And it's especially true for top talent, who are usually the most mobile employees and find alternative work really quickly. So, you know, let's think about decision-making style when we look at culture. Is it consensus, or is it autocratic, or is it top-down? Think about leadership styles. We've talked about that already. Think about how we're managing change. What's the risk factors to new things? How we deal with, you know, goals and challenges. Think about how people work together, how formal the structure is, how formal the roles are, how defined they are. Think about the beliefs people have about, you know, who the stars are, what success looks like, how people work with others. All these things make up those kind of that culture fabric. And when it comes to integration, we've got to adopt this kind of people first approach. To get cultural cohesion, we need to have some sort of culture audit to know what's there before we can think about how that's going to work in a merged organisation. Because when we know what we've got, we can then kind of codify our findings, if you like, you know, actually set out our culture roadmap for a newly formed identity or a newly formed group or team. And sometimes the culture will change between departments as well. So we've got to articulate what this looks like if we need to shift or change something. And that's where cultural artifacts are really good. You know, we have visions and missions on posters, on meeting room walls. You know, we have branding. We you know, continuously reinforce these things. We plaster it across our documentation. You know, we make sure that people buy into what we want them to know and how we want them to work. So we've got to model those changes in behaviour really quickly. You know, sometimes the fun thing about a new company is building it, is creating it. So how do we get people involved and then cascade that through? So culture, although it's a very difficult thing to talk about in detail, you'll know when you have two different cultures what the clash might be, and you'll know what you want the new culture to look like. So part of the communications piece sits really closely and integrated with improving the culture. And then the last thing I want to touch on is retention, because this is really important. We don't want that kind of them and us feeling to grow into an organisation, because that's the where people start to feel, you know, ostracised and not part of that culture and that team. So take time to get to know new people. Avoid those in-jokes about the way we've always done it here. You know, nothing could be more isolating than to feel like an outsider at your, you know, place of work. So it's really important, especially in reorganisations and redundancies, that we take time to integrate people. If we want to stop people from leaving, we've got to think about why people usually leave in the first place, because the risk rises in mergers and acquisitions. So, you know, I'm sure I read a statistic that said something like 34% of acquired workers will leave a company within a year, compared to approximately 12% who don't work in acquired or merged organisations. So it's a significant increase. So retaining people is work that we need to do, and make sure that we do that fast as well. You know, culture misalignment, redundancy, changes in leadership, lack of communication, disruption in the status quo, major changes to the way we work. These are all things that cause people to reflect about whether they want to work here or not. So we need to make some changes. We need to have some talent retention initiatives and programs, show our employees that their retention is a focus, show that we value their commitment to stay with the organisation. You know, increase your one-to-ones. I know some employers will look at share options and career development opportunities and even bonuses to incentivise people to stay. They're perfectly possible as well, but make sure you speak often and regularly. A lot hangs in the balance when employees don't feel adequately supported by their managers, because that's when they start to look for other opportunities. Make sure you diarise your one-to-ones months ahead and try not to move them. Have agendas that they can add to. Make sure we ask them how they're feeling, as well as, you know, focusing on tasks and what they're doing. Ask what you can do to help them. Take kind of measurements as well. On a scale of 1 to 10, how are you feeling right now, you know, about your current role, whatever it might be. If you ask how they're doing and they say, I'm okay, don't sit back and sigh and say, well, that sounds good. You know, what does okay mean? So always dig and delve a little bit deeper. But career pathing and career development, helping them visualize their future is really important. Think succession planning as early as possible as part of your communications. Also, conflict resolution is really important. A lot of people leave because they're unhappy about clashes and conflicts that have arisen, which is difficult to manage. And it's natural for growing pains to come following a merger or acquisition, but get on those things as soon as you can. You know, and sometimes your managers might need training or support in these different areas. So reward and recognition, you know, individual one-to-ones, career planning, career growth, succession planning, you know, these all go into your retention workplace plans. And monitor employee satisfaction, not just at the start and after a few months. You know, over the first few years, I would be doing that with some, you know, anonymous surveys. Throughout the merger, and definitely for quite a while afterwards, we should be asking these kind of questions. And showing that you're committed to continuous improvement, I think, as a result of what you hear. There's nothing worse than asking people to tell you, taking what they've told you, and then giving no feedback about it at all. So if people bother to tell you stuff, I think then you need to show that you're going to do something about it. I mean, a lot of these things are good practice, regardless of any merger and acquisition. So I've put a few of those thoughts that I've just been talking to you about up there: talent retention, one-to-ones, career pathing, career development. Flexible working arrangements is another good one, especially where people have changed location, resolving conflicts, looking at reward recognition, the retention analysis, what's actually happening, monitor employee satisfaction, and then show that you're committed to continuous improvement. And all of this sits hand in hand with how we're managing people, leadership styles, communication programs. They're all so, you know, linked together. But if we lose key people, that can sometimes open the floodgates, and you see numbers of people go, oh, well, if so-and-so's leaving, that doesn't bode well. I think now's the time to look. So if you've got key talent, make some effort to make sure that you are speaking to them and planning to retain them. Okay, I'm into my last minute. So hopefully there's been lots there to think about today, lots of good practice reminders. I've got throughout the slides, lots of tips, hopefully ideas and reminders, things to think about to try and make the people piece of your merger and acquisition as successful as possible. But definitely understanding the legislative part is very important. Get that right first, and then you're into the people and communication planning sections. And hopefully that's been helpful and useful. I can see that there are no questions. We haven't had any questions throughout. So that's all from me. Thank you very much for joining in and participating today. I hope it has been useful, and enjoy the rest of your Friday and your weekend. Thank you very much.